We'll go ahead and get started now. I was going to wait till it hit 40, but oh, there it is. Welcome to the fifth and final virtual roundtable in our series. Today's topic, we're going to explore birth defects surveillance programs and the legal considerations for public health data. If you've been joining us throughout the series, you should be fairly familiar with us by now, but my name is Justin Huang. I'm a program analyst with AMCHP's clinical and community collaborations team. I'm also joined by my colleague, Sabra Ankner, who you also see maybe on the screen. Just a quick overview for today. We are going to do some introductions, and then I'll pass it over to our presenters who will maybe speak for about 30 minutes or so. We'll stop the recording. If you haven't noticed, we are recording now. We'll stop the recording at the end of the presentation so that folks feel more free to ask questions, maybe do some peer sharing and share other thoughts. You're welcome to type into the chat. Thanks, Sabra, for asking folks to introduce themselves in the chat. But feel free to type additional questions in there. And if you would like to remain more anonymous, we do have the continued Jamboard option. I think it'll be on screen 3 that will add that in there for extra questions that you would like to ask. We will share that link in the chat when we get to that portion of the presentation. Near the end, we'll also launch a short evaluation within the Zoom polls so that we can collect some additional feedback and thoughts on today's roundtable. Of course, we would like to acknowledge and thank CDC again for supporting this entire roundtable series and all of the work that has continued in this space. So with that, I'd like to introduce our speakers for today. They're the Mid-States Region Director and Co-Director for the Network of Public Health Law. It's Carrie Wagner and Colleen Healy-Bufidis, sorry. And I will stop sharing my screen so that you can go ahead and take it away.
Thanks for having us this afternoon. I'm Carrie, and Colleen is getting our slides going, and we'll be kicking us off here. So great to be here this afternoon.
Yep, sorry about that. Do we have the correct slides up? Okay, perfect. Great. Well, thank you so much to Sabra and Justin for inviting us today, and thank you all for joining us. We're really pleased to be here. As Justin already introduced us, I'm Colleen Healy-Bufidis, co-director with the Network for Public Health Law Mid-States Region, and Carrie is director for Mid-States. I wanted to share just a little bit of context about the network to give you some background on where we're coming from. The network launched in 2010 with a goal to provide free legal technical assistance to public health departments, state and local health departments, tribal health departments. We continue to do a lot of that. We also do a much greater range of work now, contracting with different state and local health departments on different issues, continuing to provide legal technical assistance, trainings, various different resources like that. We are grateful for support from the Robert Wood Johnson Foundation for our work today, and are pleased to be here with you. So Carrie and I are both attorneys, and we start out most of our presentations with this just quick note: we cannot represent you, we cannot provide advice. We are here to provide information and happy to do that. So this is our agenda for today. Carrie and I are not experts in birth defect surveillance programs. That is all of you. So we are really looking forward to learning from you. We are here to provide an overview of public health legal frameworks, authority, and data sharing laws generally. And we're hoping that that information is useful for providing context and maybe some language to discuss the legal aspects of your work, including in the context of advocacy or whatever other context you find yourself. And we're looking forward to the discussion later on. But wanted to preface with that acknowledgement that we are not experts in this area. We're really looking forward to hearing from you all on the specifics of how public health law looks in your area of expertise. So let's start with some public health law basics. I should have gone through that on my last slide. I'm sorry. So we'll do public health law basics, then some data sharing basics, then talk briefly about working with legal counsel, and then we will move on to the discussion. So first, I wanted to go through a few key concepts to public health law. These are important to understanding public health law, particularly in the United States. So first, law is the foundation for public health action. It establishes public health agencies and authorizes public health prevention, mitigation, accountability measures. Beyond the communicable disease control activities that have dominated the news for the past 3.5 years, we all know that law is behind countless other public health activities, ranging from restaurant permitting and inspections to childhood vaccination requirements, injury prevention, a whole range of issues. Law is really important in each of these areas. In the public health legal context, I'm sure you've noticed the tension that really exists across public health law between protecting communities' health and intruding into personal liberties. And so that, was behind a lot of the pushback at times to the stay-at-home orders during COVID. But that tension tends to arise in different contexts and look different depending on the area, but it's kind of a common one throughout public health law. So public health law comes from many sources, and important to recognize it as the cumulative body of multiple sources of law, including constitutional doctrine, statutes, administrative regulations, executive orders, and case law. So just a couple minutes on the policy context, since I think that is really important to understanding public health law. Public health law stems from social compact theory. So that's a political theory that says that the origin and legitimacy of laws and government comes from individuals' voluntary association to form a civil society. We form a contract with each other and consent to the majority making and executing laws to accomplish the purposes of the society. So we all give up certain rights of governing ourselves in exchange for the benefit of living together. And so that really underlies public health laws in particular, as well as our system more generally. In terms of present political context, I think just like the tension I just mentioned, public health really operates as a collective endeavor in an age of individualism, and that can be a challenge and some contextual factor that really informs a lot of legal issues. Public distrust is an ongoing challenge. Declines in workforce investment. I think the lack of public health voice really came out during COVID, became very clear that there was kind of a lack of understanding about what public health is, especially in its breadth and depth, and just kind of a maybe a lack of voice generally there, and opportunity to hear from public health. And then political accountability is also, I think, an ongoing discussion, what that looks like and how that manifests too in response to COVID. So a few key concepts. Federalism is one of them. The federal government and states are co-equal units of government. That's what federalism means. So the federal government has only the enumerated powers under our Constitution, which means all powers not allocated to the federal government specifically, nor prohibited by the Constitution, belong to the states. So the 10th Amendment of the Constitution, which there's just a little excerpt there, states that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states. So some powers are explicitly federal. Examples there are defense, nuclear power. All powers not specifically federal are reserved for the states. Public health is the key example there. And then there are some instances of cooperative federalism, such as environmental issues. And then there's just kind of a historical tension for control over policy that has really been with us since the founding of the country. Another key concept is preemption. So in general, very broadly speaking, this is when a higher level of government can preempt or block actions of a lower level. Some examples: Congress can reserve power to the federal government, or state governments can override local municipalities and local authority. Another key concept, governance. So our government, the way that it is set up in the US, it trades efficiency to have a system of checks and balances with distribution of powers between the three branches of government. So separation of powers means that each branch of government has a separate set of powers, responsibilities, and authorities. The legislature in general makes law, the executive branch implements, the judicial branch protects individual rights. And then there are checks and balances that really allow that system to work. So the president can veto a bill that Congress passes. Congress can go override a presidential veto. And so that provides a layer of accountability to each branch, in addition to political accountability, where we're electing our representatives, and that provides further checks on power. And then state agencies. What is the function of a state or local health department? Broadly, it is to protect and promote the public's health. Mechanisms for fulfilling this function include issuing regulations, enforcing laws, and issuing policy guidance. When developing new regulations, an important function is holding a public hearing. That's important for the public to express opinions and for the health department to generate community support and educate the public. It can also help with understanding opposing arguments, identifying weaknesses, adopting changes that might build more support. And generally, most states have Administrative Procedures Acts listing what is required to fulfill requirements for establishing regulations. And then we have the judicial standards of review, which is if regulations are challenged, courts will determine whether the regulations are within a health department's authority or outside of their scope, and whether regulations violate other laws. So that provides kind of a check on that authority. And then just a few minutes on sources of public health authority. So there are four key sources we often talk about: the US and state constitutions. These establish the police powers, which provide for authority to protect the health and general welfare, and designate that as a state function. Statutes implement the police powers through public health codes and other laws. Administrative rules further implement statutes. They can be changed by agencies through notice and comment processes. And then courts, which provide a check on the exercise of authority, especially in the context of protecting individual rights. Just kind of reiterating some of that in a different way, as we just talked about in terms of the 10th Amendment and federalism. Public health is largely a state and local issue, and that's because of the police powers, which are reserved to the states through the 10th Amendment. So the police powers are inherent authority to enact laws, promulgate and enforce regulations to provide for the health, safety, and welfare of residents. So these provide for state and local public health authority, and were upheld in the seminal case Jacobson versus Massachusetts that I'm guessing many of you have come across, which was an opinion issued in 1905 and remains really strong despite some definite challenges during COVID and some different issues that kind of have affected different discrete areas, but really that standard still remains robust. The police powers, as I mentioned, are implemented through state public health codes and administrative rules, and then common law, which means case law, really the law established through judicial opinions is also important to recognizing different aspects of states' authority, including the example here, parens patriae, is the state's inherent power or authority to protect vulnerable persons and populations. And then a little bit more on the police powers. The state constitutions and legislatures generally broadly delegate power to executive branches through legislation. So this is generally granted to administrative agencies such as health departments, and also maybe delegated to local health departments depending on the state's law. There's generally broad discretion afforded to the agency to determine how to exercise their authority based on scientific expertise. For example, determining based on scientific reasoning whether and when to notify the public of a Legionella outbreak or some other similar issue. Agencies must follow administrative procedures, as I mentioned, and then regulations must be within the scope of the enabling legislation. Okay, a few minutes here on limitations on public health authority. While it is broad, there are limits. There are a couple of key sources of limitations to keep in mind: jurisdictional and constitutional. So jurisdictional limits include limits based on separation of powers between the executive, legislative, and judicial branches. Other jurisdictional limits are based on geographic boundaries, allocation of authority between federal, state, and local governments, including through preemption, assignment of responsibilities to different agencies, and then statutory limits on an agency's exercise of its authority. And then here are some key constitutional limits in the public health context. So especially those protecting individual rights are really important. Some of these rights, as I mentioned, have been emphasized in COVID-19 challenges, especially religious freedom and due process. But the other rights listed here come up in different contexts as well. For example, a health department's investigative authority is limited by the Fourth Amendment's protection against unreasonable search and seizure. In the kind of adjacent context of newborn screening, retaining newborn blood spots from newborn screening may be considered a seizure, requiring informed consent from parents, and that's kind of an ongoing issue being litigated in different areas. And then finally, just a couple of comments on public health data collection before I turn it over to Carrie. So public health has broad authority to collect data to prevent and control disease and protect public health. This authority was recognized in a Supreme Court opinion from 1977. Specific authority and general authority is established by state law, and there is a corresponding duty to protect information that is collected. Carrie will talk a little bit more about HIPAA in a few minutes, but it should not impede public health data collection functions, generally speaking. And then in terms of talking specifically about authority for birth defects surveillance programs, that's where some of the general versus specific authority can come in. Specific authority might look like a state statute that establishes the birth defects surveillance program in total, and maybe there are regulations helping to implement that, but in statute, there's authority to establish the program. General authority might look more like either a general grant of authority to make regulations or a general grant to collect data, and then that is implemented by the agency through rulemaking, through regulations that establish a birth defects surveillance program, or even just established outside of the regulatory process and kind of established at the programmatic level. So with that, I will turn it over to Carrie.
Right, thank you. So I'll talk quickly today just about some data sharing basics, and Colleen, you can advance the slide, please. And so this framework really would apply whatever data sharing issue you're analyzing. So whether that might be looking at HIPAA, FERPA, which is federal law, applying to student records, Part 2 regulations, which are federal regulations on substance use confidentiality, for example, or state confidentiality, whether it's disease surveillance, HIV, or any applying to your particular programs. The first thing you really want to do is establish the facts. So the kind of what, who, why, and how that we have on this slide. And I'll talk quickly through kind of each of those and what to be thinking about. Next slide, please. So in terms of the what, really thinking about what do you want to accomplish and what is your level of focus, right? Are you trying to have an intervention at the individual level? Are you trying to influence systems or population health with a community intervention? And you may have more than one level of focus depending on the data sharing issue that you're looking at. Next slide, please. And what data do you need to accomplish your goal? And get as specific as you can when you're at the beginning of your data project. So what data, what type of data, or what source does it come from? What data elements do you need? And that's where really getting as nitty-gritty kind of as you can will be helpful as you analyze, the law and regulations that might apply. And even if you can have all of the data, you might think about the minimum necessary, which is a particular rule under HIPAA that talks about only requesting or disclose or using or disclosing the minimum amount of information necessary to accomplish the purpose for which the information is sought. But that has kind of a general applicability in terms of thinking about ethics and how much data you might need, that concept of what's the minimum I need to accomplish the goal. Because if you collect it, you protect it and are typically responsible for it. In terms of your what to, it's important to be thinking about primary versus secondary use of data. Will secondary uses be allowed? Are they allowed under law or regulation, or say an agency policy implementing law and regulation? And secondary use is not necessarily bad. It's just important to be thinking through, and then as I'll get through later, when you're thinking about if you need agreements and whatnot, to make sure that you're thinking about any secondary uses you might make of data. Next slide, please. And then who are you sharing data with or collecting data from? This is a slide that I think really, especially as we move into like cross-sector data sharing and community information exchanges, just shows the complexity of our systems and the organizations that public health might work with. So you see in the center of the screen, that little orange dot right in the center is our public health department, so our state or local public health department. And this is really illustrating the concept of public health 3.0 that envisions public health leaders as your chief strategist for your community, and that includes thinking about all the different data sources you might need to address inequities, social determinants of health, and really start working more upstream to address issues. And the laws and policies that apply to different data sources will depend on if you're getting it from mental health facilities or tribal health, for example, or law enforcement if you're partnering with them. So lots of different data source and just data elements to consider in terms of who you're working with and who are your stakeholders. Next slide, please. And it's important to document these relationships. So not only the terms of the relationship that you might put out in an agreement, but thinking about like, who do you need to work with? Do you have existing relationships? Do you need to work on establishing relationships? And what is needed then to reflect your ongoing partnership? And again, like what sort of legal agreement might be appropriate? Next slide, please. So really important here is the why. Why are you setting out on sharing data or analyzing a particular legal, what do you want to do with the data and why? Be specific. And it's important, your attorneys that you work with and that work, on data projects with you will want to know the purpose. Like, what are you trying to accomplish and why? Is it data sharing for public health activities? Is it research? Are you providing services on someone else's behalf or on behalf of another program within your agency? Those are all key things that your attorneys or compliance officers will look at in helping you think through the legal aspects of a data sharing issue and whether you can do exactly what you'd like to do. Next slide, please. So then getting into the how, and this is like the key piece of identifying the applicable law. So again, are you dealing with HIPAA? Are you dealing with state law? Are you dealing with a combination where you might have to think through more than one law that might apply to the data that you have or that you're looking to use? So again, thinking about that legal framework, and you can see, just like we had that jelly bean slide a couple slides ago, looking at all the different stakeholders, you could make a similar one. And here we just did a little list of all the different sorts of laws or regulations that may apply. So again, HIPAA, but it could be, Identity Theft Protection Acts, for example, if you're getting outside data, that you have to keep in mind how to protect the data. Social security numbers. Is FOIA a consideration if you're bringing data in, for example? Next slide. And so your attorney will really be able to help you think through, how do you comply with the law? And I'll talk in a few minutes about some strategies for engaging with legal counsel really trying to make them a part of the team so that they understand, not only just looking at what law applies, but understand your overall goals and objectives so that they can really help you accomplish those goals while complying with the laws that may apply as well. And so one of the things to think about in terms of compliance is how do you maximize benefits of the data that you're working with or using and minimizing risks. So that gets into not only your attorneys in your kind of data sharing team, but security and information technology as well. Next slide, please. So again, how to establish and document the terms of data sharing so that you might do that with a data sharing agreement or a memorandum of understanding in the government context. MOUs, as we call it, are often used when working kind of government to government. And these will set out your legal authority, your terms for data sharing. They can provide for certain monitoring and accountability in terms of compliance, notification if one party experiences a breach, for example. It's a useful way to demonstrate compliance, that the data sharing arrangement complies with all applicable laws. But it's important to remember that data sharing agreements or MOUs are not a proxy for legal authority. You've got to have that underlying legal authority to engage in the data sharing that you want to engage in. And assuming you have that, really the data use agreement or other agreements around data sharing are those sort of rules of the road between two particular parties. Within the guardrails of what the law kind of allows you to do. And then if this is more of a service provider arrangement, you might have a business associate agreement in place, and that's an agreement specific to HIPAA, or service level agreements, for example, that just establish that business relationships and the terms and conditions for using data. Next slide, please. And so what's your role of the attorney in this process? Next slide. So really, including your organization's legal counsel as best you can into your project team is really important. We hear sometimes, at the network and working with state and local health departments, sometimes that there is at least a perception of a culture of no. And where it can be difficult to work with attorneys. And in my prior life before the network, I was an attorney at a state health department. And it just went a long way being a member of the project team and understanding the overall project goals and how the program functioned. It helped me get beyond sort of the training, where you can be sort of risk averse. We're trained to be risk averse as attorneys. And not to say that you're just pushing aside legal requirements and that, but there are sometimes more creative ways when your initial risk averseness might just be like, no, we'd be better not to do anything from a pure risk mitigation standpoint. But thinking about, does that serve our constituents well? Does that accomplish the program's goals? So bringing in your attorney kind of early and often and having them as a member of the project team, it goes a long way to helping them do all the things on this slide and define your legal pathways for moving forward. Next slide. So I talked about a lot of these already, and in terms of how you can, some strategies for getting beyond sort of the yes/no questions to attorneys, and fostering that trust to get to more of a culture of yes. And I would just want to highlight the Pathways to Yes document there. The network co-authored it with Data Across Sectors for Health last year, and it really is focused on getting to this culture of yes and strategies for public health to work through data sharing, not only with your attorneys, but as an overall team developing use cases and that. So just wanted to highlight that it may be of use in future projects. Next slide. And highlight some additional resources that we have available here at the network. We do provide, as part of our funding from Robert Wood Johnson Foundation, we provide free legal technical assistance. So again, we're not providing legal advice, but we are available to help think through and provide information. And sometimes that includes even working, with attorneys at public health departments. We've got a number of resources. We do webinars and things like this, so please don't hesitate to reach out to us if we can provide assistance. Next slide. All right, I heard in preparing for the webinar today that you all may be impacted by some misconceptions about HIPAA, and so I'm doing a very quick lightning round, just touching on a couple of HIPAA related things. Happy to discuss more. We don't have time today to get into all of how HIPAA works and whatnot, but happy to have more discussion after the presentation or later on. So I think I'm probably, not saying anything new when we all say, healthcare providers, hospitals, laboratories are crucial sources of health information for your programs, and that most of those providers are covered by HIPAA. And a common misconception, whether it be that an overly conservative interpretation of HIPAA, is that providers may question or deny access to certain information to public health. Next slide. And so quickly, what does HIPAA cover? And I want to just say here, important that the first question is, who is covered by HIPAA? And HIPAA applies to covered entities. So those are typically healthcare providers, health plans or insurers, and healthcare clearinghouses. And so that is really the first question when you're thinking about does HIPAA apply, is the entity a covered entity? And the entity might also be a hybrid entity. Many health departments are at the state and local level are HIPAA hybrid entities where HIPAA applies to some but not all of their activities. So assuming that HIPAA applies, HIPAA's privacy rule covers the use and disclosure of protected health information, which has a very specific definition. But typically, in a broad sense, it is really all individually identifiable health information. And I like to always point out that HIPAA applies not only to the disclosure of protected health information, but also to how those covered entities use it within their organizations. Next slide. And so a couple of really basic rules that the privacy rule requires. So in general, HIPAA covered entities are prohibited from using or disclosing protected health information unless it's required or allowed by HIPAA's privacy rule. And the general rule with HIPAA is that a use or disclosure must be authorized, have a written authorization from the individual. That said, there are a number of exceptions. There's exceptions for treatment, for payment, for healthcare operations, and a number of other exceptions to that written authorization requirement. One last important point about HIPAA is that if another law provides greater privacy protection, so if you have a state law, say applying to communicable disease that goes further than HIPAA, you will have to comply both with HIPAA, but then follow that state law's protection. So that can get pretty nuanced and is something that is a little unique about HIPAA. Next slide, please. Next slide. There we go. So I want to just point out real quickly 2 exceptions under HIPAA that typically apply in the public health context when you might be seeking information from a HIPAA covered entity. And these are exceptions again to that general written authorization requirement, which is often what we hear, providers are saying, sorry, I can't give you health department this information without a written authorization. So first look at the required by law exception under HIPAA, and that's really where a state law or state or federal law requires. So think in the law, you'd be looking for must disclose, shall provide type language, requiring that information. Mandated reporter laws are a good example of laws that meet HIPAA's required by law exception. And then the second is the public health authority exception, which you may all well be pretty familiar with. This is a permissive exception under HIPAA, which allows but does not require covered entities to disclose information or protected health information to public health authorities for public health purposes. Next slide, please. And so that was a whirlwind, and look forward to kind of hearing what your questions are and what experiences you've been having in your states when we get to the discussion. Just a few resources here. We will provide these slides afterwards. The links in them are live to just some resources that we thought might be of interest. Next slide. And then all that to say thank you for your attention, and here's how you can be in touch with Colleen and I if you have further questions or need legal technical assistance. And so I think with that we'll stop, and then we have a few kind of discussion prompt questions, but look forward to hearing from all of you.
Well, thank you so much, Colleen and Carrie, for that really awesome presentation.